I'm going to address this bill as a law professor and as a Catholic. And I'm going to take a few minutes to try to put the current anti-Sharia law initiatives into a broader context and explore whether the introduction of Sharia law in American courts is really a departure from our legal tradition. I think the best way to come at this is to ask, how does American law already create space for the introduction of distinctively Christian beliefs and commitments? In other words, do bills like the one proposed here defend the rule of law, or are they themselves in tension with our society's long-standing commitment to religious liberty? For example, it is routine for a court to look to the rules of a religious entity in order to resolve a conflict within that entity. If a Baptist church creates a constitution that says a pastor can only be removed by a vote of the entire membership, a court will uphold a challenge to a church committee's effort to dismiss a pastor absent a full membership vote. The fact that the church's rule flows from a Baptist commitment to the priesthood of all believers, in other words, the rule is a religious rule, does not preclude a court from enforcing it. In reality, American law has stood behind the rules agreed to by religious believers unless those rules conflict with important public policies. Courts, for example, are obviously not going to enforce a Mayan rule about child sacrifice. But in the vast majority of cases, courts enforce religious rules. To take another example, in the wake of the priest sex abuse scandal in the Catholic Church, several dioceses have declared bankruptcy. The courts have wrestled with whether to apply state property law or canon law in deciding the disposition of church property. There are cases on both sides of that question. But it's important to note that the inquiry turns not on the fact that canon law is somehow a foreign law, but simply on whether the source of law would provide the proper balance between First Amendment rights, the church's accountability for its wrongs, and the payment of tort judgments to plaintiffs. In some cases, applying canon law is the most sensible approach, and courts don't hesitate to do just that. Canon law is not a dirty word in the American court system, and Sharia should not be either. Courts have not blinked an eye about the prospect of enforcing a, quote, biblical conflict resolution. For example, in the case Prescott versus North Lake Christian School, a federal court in Louisiana affirmed an arbitration award that was based on the application of, quote, biblical law and the rules of procedure for Christian conciliation. In another case, Encore Production versus Promise Keepers, the court refused jurisdiction over the case at all because the litigants hadn't gone through the Christian arbitration that they'd agreed to in the first place. So the court said, we're not even dealing with this until you've gone through Christian arbitration. By its terms, the proposed bill is limited to, quote, foreign law, which is defined as, quote, any law, legal code, or system of a jurisdiction outside of any state or territory of the United States, including but not limited to international organizations and tribunals, and applied by that jurisdiction's courts, administrative bodies, or other formal or informal tribunals. My concern stems from the fact that Sharia does provide the legal codes of several foreign jurisdictions, but American Muslims may have agreed to follow Sharia not because it's the law of a foreign jurisdiction, but because it's a defining element of their faith tradition. When two Christians enter into a prenuptial agreement that, based on biblical principles, imposes financial penalties on a spouse for adultery or abandonment, and a predominantly Christian country takes the same approach, does the prenuptial agreement amount to foreign law simply because it happens to track a foreign jurisdiction's laws? If that's not what the bill's framers intend by defining foreign law in this way, they need to make that clear. If we're not prepared to call an American Christian's invocation of biblical principles foreign law, then we shouldn't attach that label to an American Muslim's introduction of Sharia. The bill also limits its application to, quote, actual or foreseeable violations of the constitutional rights of a person caused by the application of the foreign law. I don't know what this means precisely. If this means that a court cannot enforce an agreement between the parties in which one of the parties agrees to waive rights guaranteed under the Constitution, then we have a problem, because that rationale would wipe out a lot of what courts do every day. I'm not a criminal law expert, but I think plea bargain agreements are pretty clear waivers of constitutional rights. Now, you can't waive all constitutional rights. No one can sell themselves into slavery, for example, but courts routinely uphold agreements that would be clearly unconstitutional if they were imposed on an individual by the government. Restrictions on employment or speech would be leading examples of this sort of contract. I don't know why a voluntary waiver of a constitutional right should be precluded for religious believers if it's not precluded for non-religious believers. Alternatively, if the violations of constitutional rights language aims to ensure that American courts don't enforce a foreign court's order if the foreign procedures are not fundamentally fair or otherwise violate basic due process, I'm not sure why we need such a provision. American courts are already focused on that. And I'm not sure how or why concerns about Sharia law contribute to our understanding of this issue. If a contract is entered under duress or through coercion, or if a foreign court order is entered without a party having the chance to contest it, our courts won't enforce that contract or order, regardless of the source of the substantive norms embodied in the contract or the order. The unenforceability has nothing to do with Sharia.
I am going to focus a decent bit, actually, on the proposed bill. And I'm going to speak about that as a scholar of law and religion, also as a person of faith myself, and actually as a parent of children in Michigan. I'm obviously a Michigan resident. And I came to two conclusions. One, that the bill either does absolutely nothing of legal significance, and I'll explain why. There are actually very good reasons for this. Or the bill does exactly what Professor Vischer suggested it does, in which case it is unconstitutional for a number of reasons that I'll discuss. So let's look at the bill first of all, and let me give you a suggestion as someone who's dealt with law and religion bills, everything from school prayer bills to intelligent design bills and things like that. This is frequently what you would call a stealth bill, right? This is a bill that is designed with a specific purpose, but it doesn't state that purpose. And we see this a lot with bills relating to religion, in things like school prayer and intelligent design and things like that. The reason is to try to avoid an establishment clause violation. The bill seems to try to do three things. One is it seems to be saying that Michigan courts and authorized administrative panels and authorized arbitration panels and so forth are not able to enforce foreign laws, i.e. Islamic, potentially Jewish, and foreign, I guess, laws of foreign nations that violate constitutional rights. They can't do that anyway. There's one thing if you're saying, and this was what the Oklahoma bill tried to do, is you can't even use these laws, right? This law is saying if it violates a constitutional right, you can't enforce it. If it violates a constitutional right, you can't enforce it. You don't need Bill 4769. The contract provisions, I don't understand. Okay, constitutional rights are vis-a-vis government. Okay? It is a fundamental aspect of constitutional law that state action is required. Okay? For something to be unconstitutional, there must be state action. Now, obviously, a court getting involved is state action, but that's not what the law is talking about if the contract provision violates a constitutional right. But if the contract is between private parties, how can a contract provision violate a constitutional right? The only possibility that I could come up with, and it's extremely troubling, and it's an incredible slippery slope, which all three speakers have already spoken of, have already touched on, which is that perhaps the meaning of this provision is that were the government to have contracted, or were the government to if the government was the entity that was doing whatever will be done under this contract, it would be unconstitutional, and therefore courts cannot enforce it. So if private parties contract to do something with each other that government couldn't do to either party, that the courts will not enforce this. I find this incredibly troubling because, as has been pointed out, private parties routinely contract to do things that government could not do to them. It's a constant in all sorts of private contracts. And then when Professor Vischer was speaking, these Christian arbitration agreements, it occurred to me that what do we mean by foreign law? To the extent that these things fall under some sort of Christian conception of law, isn't that a foreign law? So isn't this bill going to ban the Promise Keepers from, from holding people to binding contracts? There's also an entire area of law and religion that deals with the enforceability of wills and trusts and religious contracts, whether or not you can have a charitable gift enforced by a religious entity. With this law, and there's, in most states, including Michigan, there's an exception for charitable devices that you don't need consideration. You don't need a bargain for exchange in the traditional sense. Many of these devices are based on religious law or conceptions of religion. If that's foreign law, does that mean now that these devices cannot be enforced and everything from a Protestant church to an Islamic community center cannot get its bequest? Because to do that would enforce foreign law, and of course government might not agree to some of the terms that would exist in these contracts, or government might not be able to, government might not be able to enforce some of these terms that are in the contract. Practice and belief are not separable. The US Supreme Court has treated it that way periodically, and today, in fact. But you cannot have belief in Judaism, which is my religion, or Islam, or Buddhism without practice. The two are intertwined. You show your love for God by what you do. Okay, that is true in Islam, that is true in Judaism, that is true in many religions.